Greetings, everyone. A very good evening to all of you present here. I, Parastu, a member of Legal Vidya, and I will be your host for the session and welcome to the webinar on understanding the procedure of arbitration by Legal Vidya. We are thrilled to have you join us as we explore this increasingly critical topic, which is becoming essential for legal professionals and aspiring arbitration specialists. Today, we will focus on understanding the key concepts of arbitration, exploring the best career pathways, and learning how you can position yourself for growth in this field. Now, I am blessed to introduce our esteemed speaker for today's webinar is Dr. Bapu Malcolm, sir. He is a seasoned advocate with nearly 2 decades of experience in litigation. He practices actively at the Bombay High Court and also appears before the Supreme Court of India and arbitral tribunals, debt recovery tribunals, as well as district and civil courts in Maharashtra, Gujarat, and Daman. He is an empaneled arbitrator with the Bombay High Court, making him a respected figure in the field of dispute resolution. Bapu sir is frequently invited to speak at webinars organized by student bodies and professional organizations where he shares his vast knowledge and experience. His expertise also extends to legal writing, having authored a regular column titled You Be the Judge in Money Life magazine with over 100 published articles. The webinar will be recorded and the recording will be shared with all registrants. I kindly ask all participants to keep their microphone muted and cameras off during the session. And please save your questions for the end. A feedback form will be shared during the webinar, so you have to fill that form. So without further delay, let's extend a warm welcome to Dr. Bapu Malcolm, sir. We are excited to hear his insights. The floor is yours, sir. Give me a second. I think sir is having some network issues. He will be speaking in 2 minutes.
Okay. Just a minute. Okay. Yeah, I know how to do it. The thumb there? Sure. If you want to switch yours, yeah, check. Hello. Yeah, shall I enable the video? Yeah, enable the video. Hello. Now is it okay?
Yes, sir, it is okay.
Fair enough. Chalo. Because I've come to Divya's laptop. I've
Yeah.
lost connection with that. Acha. Now, good evening, everybody. I'm sorry we're a few minutes late, but I'm not that tech savvy. So we always have this problem. Um, the process that we will be following today is something that we have been following for quite some time. My interest in this webinar is twofold. One is you can teach me a lot, and if I can be of assistance to you. Under the circumstances, to begin with, I would be very happy if two or three of you started with some questions so I know exactly where we are heading. Otherwise, I shall just keep on talking. Whether you are interested in those points or not, I would never know. So I request two or three of you to start asking me some questions, and then we'll get going. Let it be a two-way affair. I don't want to impose myself on you. We have, if we have a conversation, we'll know more about the subject than just one person talking. So, Mr. Chuk, would you be able to help me out on that with the others?
Yes, sure, sir. Now, I request to everyone, please ask some questions, sir, so we can initiate the session. Anybody? Sir, one question Akshat says, how we can start career as an arbitrator?
Akshay, how many years have you been in the field?
Yep.
Will
Every
Akshay be able to answer?
2 years in litigation.
2 years in litigation. Akshay, have you been in any arbitration proceedings
No, sir, in mediation.
in mediation? Um, before we go further, I'd like to tell you something. I'm for arbitration and I'm also against arbitration. I like it and I don't like it. I like it because it's an easier way to solve problems. I don't like it because problems are not getting solved. It has become more or less of a trial court. If you, anyway, we will come to that later. So, Akshay, to tell you the truth, first of all, there's a 10-year limit which they've put on you. And I don't know which firm you are working for or whether you are independent. But if you can attend some arbitration sessions, if you can work with somebody on arbitration, say for just for 3 or 4 sessions, 3 or 4 matters, it will give you some idea of what arbitration is and what it should be. But let me tell you, if you are very, very diligent about this, you will be disappointed. The way things are going, you will be disappointed. Now, if you ask me, how do you start? I said, I've told you how you could start. First of all, you've got to learn the ropes. And only then, I know it's very fashionable for people to say, I'm in arbitration. I remember people coming out of college, and the first thing they tell me is, I'm in arbitration. I'm in arbitration. I don't know what they understand by that because to tell you the truth, I myself don't really know how arbitration could help. So I suggest you please wait, don't rush into it because you can't rush into it. And you'll most probably not be very good at it. At least for a few years, you have to just sit and listen, just watch. That is, in law, the best thing to do is to attend a court or a session and quietly sit in one corner and see how things are going. That is the best way to learn anything in law. Sharon, what next? Come, please, somebody else come up with a question.
Next question is from Varun Sharma. What do you suggest for fresh law graduate?
Well, I just said, I mean, Akshay is 2 years into the business, so I would presume that that's the fresh thing. See, I'll tell you, I was expecting this question, and I was expecting everybody to ask this question. I want to get into arbitration. To tell you the truth, it is no big deal. Arbitration is no big deal. Please understand that it's a big word. Arbitration is no big deal unless you learn the ropes in trial courts, in appeal courts. You cannot be good at arbitration. It's impossible. So when you say, how can I get into arbitration? As I said, first, please attend the courts, attend matters, read up on, see, you'll either be for the plaintiff or you'll be for the defendant, you'll be for the respondent or the applicant, whatever it is. Read the briefs and sit in court and see how things are going. In another 4 or 5 years, it cannot be done tomorrow. It's out of the question. In another 4 or 5 years, you will be ready to take on arbitration yourself. And unfortunately, by then, the book that we have just now will most probably be outdated because arbitration rules keep on changing all the time. So it's very difficult to keep up with them. So please don't expect it to be a magic. Attending this webinar is some sort of a magic wand by which tomorrow you'll be either an arbitrator or in arbitration proceedings. I'm sorry, but that's the that's the truth. Okay, next.
And the next one is from Mr. Fikri Panto. Is it mandatory for us to be member for arbitration chamber such as CIARB organization to become professional arbitrator?
I am very glad that you asked this question. I was hoping somebody would do it. Um, if you people have been following LinkedIn, about 15, 20 days, we had a bit of a discussion on this. Now, let us first understand what arbitration is. When two parties, or maybe three parties, whatever it is, but usually two, have a dispute, and I'm going a little bit further than commercial disputes because most arbitrations are in commercial disputes, most of them. And that is something that I don't really like because commercial arbitration means talking in rupees, annas, and pies or rupees and naya paisa. It doesn't really interest me. But when two parties cannot see eye to eye, they want, they have to sort out the problem. Now, one of the ways of doing it is to go to court. Uh, the court, somebody is the plaintiff who has a problem, somebody else is the defendant who has something else to say, and the court gives you a decision. Arbitration, only the terms vary. Instead of plaintiff and defendant, you have a claimant, and uh, instead of giving a judgment, it's an award. It's semantics, a change of names. But there are a few important things that arbitration involves. One is that in a court, you cannot choose a judge. You are stuck with it. What the master of the role says or what the register gives you, you have to stick with it. Very rarely can you change the bench. It's not possible and it should not be done unless you have some very good reason. Here in an arbitration, you can select the arbitrator. And sometimes I feel that when a contract is made and there is an arbitration clause, it might be wise to appoint somebody as an arbitrator or say that if it goes into arbitration, we would like this person. I'll tell you why I'm hunting for an arbitrator. I don't think it's being done, but I see no reason why it cannot be done. So you have Mr. A as your arbitrator. You mention him in your contract, and in case we go in for arbitration, we'd like to go. Nothing compulsory. You can still have Mr. B or Mr. C. But if you have Mr. A, it might help you speed up the process. So in arbitration, you have a choice of who is going to decide your matter. Another thing is they call it alternate dispute resolution. Is it fast? I think not. If you look at I've got it here with me. If is it clear? Can you read it, Mr. Chu?
Yes, sir. The Arbitration and Conciliation
Yeah.
Act of
Now,
2068.
now this book, if you read it thoroughly, I think there are a lot of contradictions, extreme contradictions in that, primarily because things keep on changing all the time. Now, arbitration is almost as old as justice by a court. Any two people having a problem can appoint anybody to solve it. There is nothing that says that you must go to a court of law or that you have to take up a person who has been appointed by a court of law or what they call the councils. They appoint arbitrators and you have to, I mean, you don't have to. They appoint the arbitrator and he arbitrates in your matter. I think that is incorrect. The two warring parties should be able to decide whom they want to appoint and go ahead with it. And I see nothing. Of course, in the act, you'll find both contradictory things. One is yes and one is no. Um, I see no reason why the warring parties cannot appoint an arbitrator who is neither in the legal profession nor been appointed by the courts. Of course, if you can't see eye to eye on an arbitrator, then naturally you have to go to the court and the court will appoint somebody. Now, here we come back to commercial arbitration. Most of the arbitration that I see is commercial, but it becomes commercial because there are some other facets involved, technical assets involved. I mean, most of the major decisions taken in arbitration also involve a lot of technicalities. So it is not just finance. It is not just rupees and paisa. There's a lot more to it. And this is my personal opinion. Beyond contract, beyond what the law says, how much of an experience does a court appointed arbitrator have in sorting out the matter? If you ask me personally, I do not like commercial arbitration. It's messy. What type of arbitration would I like? And then I realized that there are so many other fields in which arbitration is not only okay, not only necessary, but it should be made compulsory. One of the, see, professionalism in sports has come up very recently. Of course, we were the first in India to do it about 42, 43 years back. It involves a lot of contracts in sports. It involves sponsorships. It involves the uh, the holding of events, advertising. Now, all that leads to media. It leads to, well, it could lead to problems because there's big money involved and a lot of people involved. I do not see how a person just picked up by the court because he's an LLB or an LLM or a past judge would be able to do justice to this. In a court of law, there is a lot of time for the judge to be taught. I personally believe that a judge, the best judge is somebody who doesn't know anything to begin with and allows the advocates to teach him because that's the way it should be. But if you plant somebody into a litigation other than commercial or other than just plain contract law, I find it very difficult to believe that justice will be done. And invariably, as happens all the time, the losing party, the one against whom the award is given, goes to court on some pretext or the other, and the matter starts all over again. Here, unfortunately, there are so many loopholes, there are potholes, there are all sorts of holes which allow you delay, delay implementation of the award. I would not say execution because that would be a judicial word. So, besides commercial litigation, there are many other fields. Um, I, personally, I'm interested in technical and sports because those are my fields. Now, all of you might be interested in something else, maybe um, patents, trademarks. Why go to court and fight over it when the matter can be settled by an arbitrator in hopefully a short time? Now we come to the matter of time. Everybody says that court cases take years. Frankly speaking, I do not believe in it. My first court case ended in 10 minutes with a victory. There are so many other times also that we have got winning orders on day one. So I cannot believe that court cases go on for years. Unless, of course, people want them to go on for years. It's not the fault of the judiciary. It's either the fault of the litigants or the fault of the advocates. I'm sorry to say. But matters need not go on so long. But since they do go on so long in a court of law, people think that that an arbitration would help. Now, how would an arbitration help? There is no particular time limit, and as in all things in law and in the statutes, there's always some escape route, some reason why you can either extend or not extend, whatever it is, but there is some escape route. If you take up arbitration, and this is what I believe should be the case, all matters should be sorted out within 6 months. It cannot be more than that. In a court of law, judges have a lot of other things to do. So maybe you won't get a hearing every week or even every 15 days, might be once a month. In an arbitration, you can insist on almost a day-to-day hearing after the preliminaries are over, or maybe every 2 or 3 days, so that you can come to a decision quickly. But I think if you cannot sort out a matter within 6 months, um, you are not a good arbitrator. You just can't let things. I have been in arbitrations where matters have gone on for years. I mean, it's meaningless. I mean, you can't meet once a week or once in a month and think of arbitration. Might as well be in court. And then finally, somebody finds some fault or the other with the award and goes to the court. So if you, I personally believe it should be in as short a. If you ask me to break up the 6 months, I'll tell you how I would do it. I would ask the two parties, first of all, to put everything on paper, the claim and the opponent, whatever he has to say. It should be over in the first 1 month. Everything should be in the hands of the arbitrator. He goes through it, then sets a date, and have at least one hearing a week, at least. Before the first hearing, there is also another way in which you can do it. Now, if you will read the act, it says arbitration and conciliation. But in one of the pages, in very small font, though it is bold, they also mention mediation. Conciliation is the best when somebody gets the two parties together and agree on something, and that finishes up the matter. Mediation is almost the same, where a mediator sits and asks the two parties to come to some agreement, and if they do, well and good. If they don't, the matter is sent back to the court. Finally, arbitration. If you can get the matter sorted out by conciliatory processes or by mediation, nothing like it. And I would sincerely suggest that all arbitrators should discuss this matter before going into the formalities of arbitration. And if it can be sorted out before that, nothing could be better. And if you have to go to court to sort of register the matter, no changes after that. You go to the court with your papers and say we are to have we had this dispute and this is how we have done it and these are our consent terms. The court will accept it and the matter will be over. This is the way I feel that arbitration should work. And this is the way arbitration has been working for ages. Arbitration isn't something new. In fact, if you go through the Act, you'll find a mention of arbitration 100, 200 years back officially. But any two people having a problem going to a third person and the third person solving it is arbitration. You come to some agreement. So don't think of arbitration as something big. Of course, Arbitration for some people is a very lucrative proposition. And sorry to say that arbitrators have been rather lax when they are paid more. So there are norms laid out, but I don't know how well the norms are kept or not. But if you want to finish it off in 6 months, I think it should be a pleasant surprise for everybody. Has I may have gone a little bit beyond your question, but I hope I have been able to answer it correctly. Mr. Chug, it's
Yes,
all
sir.
your.
The next question from her. Yeah. Practical differentiation between all ADR methods and scopes.
Just a minute. Please come again. All different
Practical differentiation between all ADR methods and scopes.
scopes.
The scope of all the ADR methods.
We've just discussed that a few minutes back.
Sure, sir. The next question from Bandhani Ghosh. Sorry if I am not correcting the name. Sir, I am a third-year law student. I have just an idea that arbitration is an alternate dispute resolution. What it exactly means, sir?
What's your name, sir?
Mine?
What is it? Mr. Ghosh.
Bandhani Ghosh.
Yeah, Mr. Ghosh. You and I are uh, at loggerheads about something. There are options. We go to court. Suppose I have taken money from you and I don't want to return it. So naturally, you go to court to recover it. Alternatively, when you say alternate dispute, alternatively, we could appoint somebody who would listen to both of us and say, well, so Malcolm is right or Ghosh is right, and this is how it should be. It's an alternate method of a dispute resolution. This ADR is a very big, I mean, three words meaning settlement. Simply as that, some sort of agreement. So instead of calling alternate dispute resolution, you call it, we have reached an agreement. It's more than enough. That's what it all is. Am I am I am I helpful on that, Mr. Ghosh? Sachuk, will you put Mr. Ghosh on again?
Yes, sir. He has said got it, sir. He has message in the niche.
Do I read the message? No, I
Yeah.
can't read anything. I'll be happy if they can speak with me. Oh,
Sure,
it's a
sir.
she.
Wait a minute.
Oh, I'm so sorry. I'm so sorry. I am so sorry. It's a she.
Mr.
I will
Mr.
correct my. Yes, yes.
Mr. Ghosh,
It's
you can speak.
No problem, sir.
a,
Sir, I got it.
if you had spoken to me, I would have been able to find out that it's a girl and not a boy.
Mhm.
Yeah, I can see the face now. I can see.
Mhm.
Yes. I'm so sorry.
Sorry.
Forgive me.
Yeah.
Because we had a couple of the guys, and then I thought that this would also be a male. Anyway, Miss Ghosh, uh,
The
I,
next,
I'll read. I'll try to read. Unfortunately, I'm on the laptop, so it's becoming a little bit difficult.
sir, the next question from Priyal Agarwal. What are your suggestions for LLB students?
First of all, get through the examination, which is a very easy thing. I mean, LLB exams. It's a but if you are if you are a student who has time on his or her hands, Miss Ghosh, her hands. By the way, the law says if I say his, it also means her. And if I say he, it also means she. If you have the time on your hands, please go and sit in court every single day, every waking moment. The more you sit in courts and see, every court building has a number of courts. If you're in a Mofussil area, maybe two or three. If you are in a city, 10, 12, 15 courts. Visit the courts and you'll soon find the chords which interest you, or where the action is means arguments, cross examination. Cross examination is a very important thing. So please visit all the courts that you can. Forget your movies, forget your television, put away what, your mobile phone, and go and sit in court as much as you can. I guarantee you that you will learn 100 times more by doing that than reading each and every act for which you give an examination. The examination, in my opinion, is nothing more than allowing you to wear bands. Beyond that, it is nothing. It has to be a very practical experience. You have to be in the courts. Now, suppose you cannot be in the courts. How do you spend your 3 years or 5 years, whatever it is? I prefer the 3 year course because you're a little bit mature by the time you start. Otherwise, after the 12th, I've taught 5 year students, and I find that uh, they're a lot less mature than the people who have graduated. Now, if you cannot go to the court, what would you do? If you cannot go to the court, start reading judgments. All of you have your mobile phones, you have your laptops, you have your computers at home. Subscribe to sites where you can read judgments. You don't have to read all the judgments which interest you. Now, head notes is not enough, mind you. Head notes is only a signboard. It may not give you the information that you really want. If you cannot do it, please start reading judgments. Another thing is, if you want to get going and maybe even earn a little bit of money, I find two things which you can do within after your first year. You will have enough experience. If you are living in a cooperative society, take up the society's work. Go to the secretary, ask him what the problem is, go back home, look up the books, advise your secretary. For all you know, your secretary might be a lawyer himself, which will be much better. You can assist him. And the second thing is writing wills. There is no law which says that you cannot help your secretary. There is no law which says you cannot help people draft wills. A person can draft a will on his own, so why don't you help him? So when you start doing that, you'll get into the groove. And you might ask, I don't know anything about wills. What shall I do? Well, we are always there. I am there. My wife is there. In case you need any help, please get in touch with us, even over the phone or an email. No WhatsApp, because I don't like to look at things on WhatsApp, as it is my eyesight is not that very good. And uh, if it's on email, I'll be able to reply immediately. Or better still, you can send me an email and then discuss the matter. But start with these two things: helping out your society, wills. These are two things for which you need very little experience, and you will learn as you go on. Another thing, please do not learn how to write wills by something on the net. It will lead you to gross. I know that there are sites where they say write your own will, this, that, and the other. But unless you discuss this matter with the person concerned, you will not be able to do. Not only will you not be able to do a good job, you might get that person in trouble. You might make a will which will be fought over for 10, 15. So you have to be a little bit careful on that. But as I said, we are always there to help you. Just yesterday, I was with a very, very old person, almost a century. And something had to be added to the will. It took a couple of hours to discuss it. And then I said, fair enough, we'll prepare a draft and give it to you. So When you talk with people, you come to know what their problems are. And mind you, drafting a will can be a very, very involved affair. The permutations and combinations are so great that you'll learn a lot more. But anyway, we are digressing from the arbitration. So let's get on to that track again. Tell me now, what else would you like to know on arbitration? Whether you can be an arbitrator, if you're over 18, please go ahead. You can always be an arbitrator. There is no law which says you cannot be an arbitrator. We had a long discussion on LinkedIn. Mr. Chug, were you there on LinkedIn when we were discussing this 15 days ago?
No, sir, I am on about that.
Acha. Because we had quite a good conversation on that as to who can be an arbitrator. And I said that if suppose I put up a signboard outside my office, Bapu Markham 12 standard pass arbitrator, would I be breaking the law? Now tell me, would I be breaking the law? How many of you think that I'd be breaking the law? Tell me. First of all, who thinks I'll be breaking the law? One by one. I put up a board, Bapu Markham, 12 standard pass, or maybe 10 standard pass, arbitrator.
Please answer in the chat box.
One by one, tell me, what do you think? Would I be breaking the law? Would I not be breaking the law?
Nitin Kumar Singh said yes.
I'll be breaking the law. Okay, who else?
And some people says no. And Akshat says it depends on the situation and the case to case that you are breaking law or not.
Akshay, you'll make a very good lawyer. You never give a proper answer. Every answer starts with, it depends upon.
And many people said no, no. And Ananya says it depends. Akal
Yeah,
Gedam says
that's the best lawyer who says it depends, doesn't
mm,
give a proper answer.
Priyal says it depends. Mahima says no.
Anyway,
Aditi
uh,
says yeah, sure. Sir.
initially a lot of people said, yes, I'd be breaking the law. And then we started discussing the matter, and they came around and said, no, I would not be breaking the law. I'm not saying that I'm a lawyer. All I'm saying that I'm an arbitrator. So how can I be break? How would I break the law? I am there to help two people settle the dispute. I mean, if a husband and wife are fighting with each other and some relative of theirs comes along and says that, okay, do this, that, and the other, and the matter is sorted out, is it illegal? Helping somebody, is it illegal? No, it is not. So you can be an arbitrator at any time. You don't need a degree. In fact, in fact, there might be some problems that a lawyer or an engineer or an accountant may not be aware of, but some person in your village, in your city, who knows about it might be the best person to arbitrate. So anybody can be an arbitrator if you know what the problem is, if you are very fair to both parties. Normally, an arbitrator should not be known to both the parties, or they can select the person, saying that, well, he's going to be a very fair person, and we will not have any problem with him. Hmm? Have I answered your question? What else, Mr. Chug?
The next question is the what do you mean by arbitration and why do we need arbitration?
Who is this gentleman?
So the what do you mean by arbitration is Miss Urvashi, and why do we need arbitration is Mohammad Tausif Zaman.
Just 1 minute. One question at a time. I'm an old man. Don't load me with too many things.
So
First, what is the first
first
question?
question is from Miss Urvashi. What do you mean by arbitration?
Urvashi, why don't you look up the net and ask this question? What do you mean by arbitration? You'll find a very good answer on that. Going back maybe 1,000 years back, it will tell you what arbitration says. Arbitration is nothing more than settling a dispute. The person must be very fair, very honest, understand the problem, not take sides unnecessarily, and finally come to suggest a solution. See, there's one thing. As conciliation mediation, they can suggest a solution. In arbitration, you'll get an award, which obviously you're supposed to follow. So that's what arbitration is, settling matters. It's like a judge who does not sit in a court of law and a judge who invariably has only one or two matters on hand and solves them out quickly. Am I clear on that answer, please?
Yes, sir. Thank you, sir.
God bless you.
Okay,
What,
thank
what
you. The next question from Mohammad Tausif Zaman is why do we need arbitration?
Muhammad, have you ever been in a place where there is no dispute? Have you been in a utopia where everybody sees eye to eye and nobody has any problems? Now, yesterday I was in a bus. I got a 20 rupee note, which was rather old. On my way back, I gave the 20 rupee note to another conductor who refused to accept it. He simply refused. He says it will get torn later on. Not that it was torn, it will get torn later on, maybe in his hands. It's a dispute. Now, what do I do? Maybe somebody in the public might have said, no, give him another note, or somebody would have said, no, accept the note, and the matter would have been sorted out. That's arbitration, just a matter of solving problems without going to a court of law. So we are humans. We are not going to see eye to eye on everything, and we need people to help us out. So that is why you need, whether it's arbitration or whether it's a judicial decision, you need something to sort problems out. Otherwise, you'll have to go to a don. तो भाई के पास जाके settlement करो. And which is something which, when everybody says that there are too many cases in court, I remember one Chief Justice of India, I think Justice Amadi, who had said that I'm glad that there are so many cases in court because people are not trying to shortcut it by going to unhealthy people. Arbitration is just one more facet of solving a problem. Mohammed, am I okay? Hello?
Sir,
Yeah, tell me.
yes, sir. The next question is just a second. Yeah, the next question is from Vidhi Beth. How can we start arbitration as profession?
I think this lady must have come in a bit late because we already have discussed this matter.
Sure, sir.
Do you want me to repeat it? In short, it'll take you a little bit of
Yeah.
time. Well,
She,
attend the course, learn the ropes, and then start. And
she has
in
heard, but she has like write the question in the between the meeting. She has heard, like she is joining from the starting.
now, will you come again on that, please?
Yeah. Next question from Vishwajit Kumar Chaudhary. Sir, can I work abroad in arbitration?
I'm glad you asked that question. One of the problems with arbitration is that there is a lot of arbitration between countries, inter-country, and that is where most of the problems start. Now, suppose I have a problem. I'm starting a business with my company in India and another company somewhere else. I won't take the well known countries. I'll take some country in, say, Nigeria. I have a problem. Both of us are doing business. We say that if we have a problem, we'll go in for arbitration. Now, here is where the problems can start and never end. And here is where you need to be very your contract. There is always an argument whether seat or place or what application law, what language. It's interminable. So if you are going in for, if, if suppose somebody comes to you and says that I'm starting business with another country, but in another country, and draw up a contract for me. Please be very careful with the arbitration clause. Otherwise, there'll be a never-ending stream of disputes. You won't get on with your arbitration. You'll be going to court and sorting out other matters. Languages. Which language do you do? Which country's law do you accept? All sorts of things. So you have to be very careful. It will depend on what the contract is, what the situation is, and only then you will be able to sort it out. But if you can, please put it down in writing from the very beginning. Now, suppose I'm in 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 a business with somebody in Nigeria. He would like the matter to be discussed in Nigeria because you always feel more comfortable at home. I would want it to be in India. I'm more comfortable here with my laws. There's an option, a third country. Like our cricket matches, when Pakistan and India don't play together, they go to Dubai and play it. So that sort of a thing. But even then, you have to. That's why if you read the act, you'll find it. It's all available there. Where to have it, how to have it, what laws to follow, what languages to follow, whether there be one arbitrator, three arbitrators, one appointed by the court, or one are you selected, then two more selected. Well, it's all given there. But please be very careful and go, go through the minute things before the contract is drafted. I'm not saying that there'll be no problems after that. There will be problems. Everybody likes to get away from these sort of things. But if you draft it well enough, the problems can be minimized. Okay. Now what else?
The next question is from Radha Kumari. Sir, I am a second year student and I want to know what skills we needed to become arbitrator.
Mr. Chug, I was expecting these questions all the time. And this is a question which a lot of people ask. It's not that easy. You cannot just jump into arbitration. You have to spend a few years in the courts. You have to spend some time visiting arbitration centers. You have to spend some time with senior advocates who are in arbitration, sit with them. Unfortunately, arbitration is not something which anybody can visit. It's not like a court of law which is open to the public. So you have to take permission if you find a good arbitrator who is helpful and ask him or her, may I come and visit your arbitration center? And if the other two parties have no objection, you can sit there and see what happens. But until you practical, you won't be able to do anything. And as I said, the act is so involved. It has been turned and twisted over, and I don't know what they have done. But I wish somebody would sit down and write it completely anew. So, unless you visit the place, unless you are involved in arbitrations, it's impossible for you to say I'm an arbitrator. It will not work. I'm sorry, but that's the truth. Tell me what else.
So the question from is S Sonu. Arbitration proceeding is also taking too much time to solve the litigation now. Still, we are choosing the same. Why? What's importance of it?
Sir, I'm fully aware of that, and that is why I said I'm not in favor of arbitration. I like arbitration, but I don't like it. I like it because it is a way of solving problems. I don't like it because it becomes a trial court. Everybody goes back to the court and see. There's a reason why a lot of people, especially in commercial arbitration, a lot of people want to go to court. Now, normally, a court will award you 5% or 6% as penalty if you have lost the case. That means the award is against you. But if you can extend the matter by 2 years or 3 years or 4 years, instead of paying the banks 14 and 15%, you are using your opponent's money at 5 or 6%. It's a trick that a lot of people use. Now, if you are in a place like Singapore or maybe London or New York, you can't use this trick because the interest rates are lower. So people try to avoid a solution by going to the court and extending the matter. Now, if you got a say 100 crore of rupees in an award which you have to pay, and you delay it by 2 or 3 years, you are using that money at 6% instead of 15%, which you would get to a bank. You're earning, well, not earning, but at least saving 10% a year. So people do these sort of stunts. It's not right, but then it's business. Why not? So as I said, the arbitration should take effect within 6 months. Don't give anybody any time to play the fool. Decide first of all. Say that these are my fees per month or for 6 months, and I will settle this matter within 6 months. If I find anybody lagging, I will consider this as an adverse decision on that person's part, and I'll go ahead with it. Make it very clear. You have to help me sort out the matter as soon as possible. It's unfortunate, but as I said in the beginning, it's become a trial court. You go back in it. And unfortunately, there are so many ways in which you can appeal. So many ways, so many loopholes, and people exploit them. Sometimes it might be better if the two parties say that yes, whatever the arbitrator says, we will accept and we won't go to court. We'll accept that as the final thing. But that's the way it works. Tell me what else. I would be very
Mhm.
happy if a particular set is laid out by not necessarily followed because in every law there is a loophole. In case of this, provided that, all sorts of things. But say that this is the way it should work. Where first month, second month, third month, so and so, so and so, so and so. Tell me what else.
Then the next is it means to be an arbitrator, no qualifications required except as to be an attorney.
See here again, if you read the law, you'll find both. You'll find both possibilities. And as I said, the arbitrator, if appointed by the court, can be whatever qualifications the court insists on. Because after all, they are responsible for the arbitrator. But otherwise, what is it that will stop you if two people are fighting with each other or on the warpath? What is it that can stop you from asking somebody to help? Which law will stop you? Otherwise, even if you have a disagreement with your father, mother, brother, or sister, are you going to go to court every day? Obviously, you'll find somebody who will help you out. So where is the question of saying that it must be a lawyer or an LLB student or an LLM student or a PhD student or the 10 years experience, this, that, and the other. But if the court appoints you, then they require a certain amount of experience, a certain degree, which is normally law. But then if you will go through the book, you'll get it. You can be a qualified engineer, you can be a qualified chartered accountant, you can be a qualified cost accountant, depending upon and there again, after a few years, and not when you pass out. You can be appointed if the problem can be pinpointed. If it's a matter of cost, and you appoint a cost accountant, obviously it will be much better than appointing a BA LLB who know nothing of cost accounting. Or if you have, say, a bridge has fallen down, and you appoint an advocate who's an BCom LLB, what would he know of structural engineering? What would we know of concrete? What would he know how it is cast, how it is tested, what the load factors are, whether the soil the selection was correct or not? Took the help of a structural engineer. so much the better. Appoint a structural engineer who's got 10, 15 years experience, then he'll be able to go through it. In fact, I always bring up this problem of saw limited in which is considered saw. Come again, Sudha? Yeah, saw pipes. Saw pipes. It's a very classical case and comes along in almost every book. It is. Uh, Now, SAW stands for a particular type of welding, spiral welding. That's the type of pipe. Normally, a long pipe is welded along its seam. That means from one end to the other. There are spirally bound pipes, welded pipes, which is a strip that is turned round and welded, which makes it a lot stronger. Now, I know this because I was in the field for 40 years and I know exactly how this is done. But now, if suppose there were a case like that, maybe if I were appointed as an arbitrator, I would even know the technicalities of whether the job has been done properly or not, whether the welding machines were correct, whether an X-ray was taken on on the welds, whether the welds are finished correctly or not, whether there was a proper weld preparation, all these sort of things. Now, what would a person with a BA LLB know about this? Of course, the advocates are supposed to teach them what was wrong, but then the advocate should also be competent enough in that particular thing. So there's nothing wrong in appointing somebody other than a lawyer if you find that the person is competent. So I see no reason why even a non-graduate or semi-literate person cannot be appointed as an arbitrator. If he can solve the problem and more people get off the table happily, he's a good arbitrator. Anything else?
Yes, sir. The next question is from I am pursuing LLB final year. If I want to be an international arbitrator, what should I do?
International arbitrator.
Yes, sir.
My God, first you got to be an arbitrator. International arbitration is very big business. The fees run into millions and millions of pounds. I have a friend, uh, Sarosh, who is into international arbitration. If ever you go to England and you want to join his chambers, I might be able to tell him to appoint you. International arbitration is a very big thing. It's fight between countries. Now, I don't think that any of us is fit enough for that sort of thing. At least I'm not. That's for sure. So international, it's too big for us. But if you want to be an international arbitrator, it will take you 10, 15, 20 years to be a good one. And then you'll have to learn international law. It depends on what the two countries are fighting over. Is it a boundary dispute? Is it a riparian dispute where there are rivers involved? Whether it's supply of electricity? Now, we have a problem with India and Bangladesh. Obviously, somebody who knows what the how it is generation, how it is transmitted, how it is used over there, whether the calculations are correct, whether the meters are correct, all sorts of things. So naturally, somebody who would be capable of doing both, knowing the laws of both countries and these technicalities, he would be the right person. Normally, inter-country relates to boundary disputes, very big money involved between two countries. A country has taken a loan and has been unable to repay, that sort of thing. But I don't think that you or I or any one of us can go into international arbitration tomorrow. I'm so sorry. Sarosh, what's his? I'm very bad with names. I'll tell you. He's a very, very important arbitrator, very big arbitrator. One of the first persons to set up a firm in England, an Indian to set it up in England. Hold on. What else?
The next question is according to you and your experience, what is more difficult and easy between corporate and litigation?
See, litigation is a bit of fun. Uh, Arbitration is a little bit serious. In litigation, you get time to study things, maybe 15 days, 15 days. In arbitration, you have to be well prepared because things happen quickly. So in arbitration, you have to be very well prepared. You cannot learn on the job. You have to learn before the job. In arbitration, I mean litigation, you can learn on the job. So uh, if you really look at it, litigation would be easier than arbitration. But doesn't mean that you. Uh, just, 2 days back, we were discussing matters, and one advocate openly says, "I never read papers. I just go to court and argue." I don't know whether it's a good thing or a bad thing, but in litigation, you can get away with it, not in arbitration. The arbitrator will come down heavily on you. So, litigation, in fact, litigation is a base from which you can move on to arbitration. So, litigation obviously is easier. Does that answer your question? Hello? Hello, sir, are you still there, Mr. Chu? Mr. Chug, are you still there?
Your voice is breaking in between them. So yeah. The next question is
Now, oh, somebody else's voice or my voice?
your voice, sir. Now it is
Now am I clear?
yes, sir.
Okay.
The next question is from Hamid Ali Rind. Sir, I am in fourth year of LLB, so should I focus on study or should I join court?
Both. You got to first get out of that college, give your exam, pass. That's the first thing you should do. But I would sincerely suggest if you have the time, please go and sit in the courts. Sit in the courts, you will find interesting matters in the certain courts. You will find the judge to be interesting. So go and then spend more time in that court, but do both and see if you can. Please go to both the courts, civil and criminal. Don't just go to one type of courts. Knowledge in both the courts is always very easy. It's always helpful. So please do that. And mind you, courts are public places. You can walk into any court. Even if you're not a lawyer, you can walk into a court. And anywhere in the world for that matter. Unless, of course, it's some sort of a dictatorship or a very restricted place. You can visit any court. Where are most of you from? May I know that? May I know from where you are?
Uh, Mr.
Just one
Mohammed,
minute.
Mr. Mohammed Tosif Zaman.
Yes.
No, 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 sir. I am asking just a
Just,
second.
yeah, please ask him. Sanoshi surname so. Hold on.
Mr. Hamid Alirin, where are you from?
Dictator. London.
Mr. Hamid,
That fellow who written the book.
I am asking you, Mr. Hamid, where are you
Oh,
from?
Saibala. Yeah, excuse me, just 1 minute. I was talking of that gentleman. He's Sarosh Zaiwala. Now, if you want to be an international arbitrator, if you can get into his chambers, nothing like it. He's one of the biggest arbitrators in the world. Okay, next. What was this? Where were we?
Yes, just a second. No, no, no. This is
I
not.
wanted to know where they were.
Sir, I think he is not in the meeting currently. That's why.
Okay.
The
Okay.
next question is from KS. Especially when the award is legal binding, can anyone give the judgment as an arbitrator?
No, just a minute. Please go slow. What is it?
Especially when the award is legal binding, can
Yes.
anyone give the judgment as an arbitrator?
No, I don't get it. If the award is legally binding,
क्या कोई can anyone give the
yeah,
judgment as
no,
an
no,
arbitrator?
no, just 1 minute. As I said, you don't need an arbitrator. I mean, you don't need a lawyer to be an arbitrator. I am glad this question was asked. I was thinking about this morning as to how I would answer it if it were asked. Now, suppose you and I, Mr. Chug, have a problem. We go to an arbitrator and the arbitrator says this is the way it is to be solved. And we solve it. If suppose I have to pay you 100 rupees and you say no, I have to get 110 rupees from you. Now the arbitrator might say that, well, either you are correct and I have to pay 110, or I am correct and I have to pay only 100. Or before arbitration, he might mediate and say, कि चलो 105 रुपया मैं settle कर दूंगा, but I go into a fight for such a small thing. Now, if I give you the money and you accept it, the matter ends. You don't have to go to court. So there is no problem left to go to court. The arbitrator has given an award and you've settled it. But I refuse to pay even after the award. What next? How do you enforce the award? The arbitrator has got no right or no power to come into my house and say, चलो 100 रुपया दो, 110 रुपया दो. He has no right. In which case, you will have to go to court to enforce it. But otherwise, if it can be sorted out, why go to court? It's a matter of solving a problem which the arbitrator has done. Matter ends. Now, what was the second part of this question?
Second part is, can anyone give the judgment as an arbitrator?
See, nobody gives a judgment as an arbitrator. It's a fancy word for a judgment and they call it an award. See, it's called an award. The person who otherwise would be a plaintiff is called a claimant. He's claiming something. These are just semantics. But I can, if I'm an arbitrator, I can't give a judgment like a court, but I will give an award. I cannot give a judgment as the word judgment and award might mean the same thing, but I cannot give a judgment as an arbitrator. I can only give an award. What else?
The next question is, sir, I am curious to know, can arbitration be used in Indian insolvency matters like other nations such as United States, Japan are using it efficiently? It will be very great. You can share your opinion on or view on it.
I think we discussed this matter just 3 minutes back, 5 minutes back.
Okay, sir.
Uh,
The,
it's
sure,
a
yes.
matter of commercial terms between countries. If they can sort it out by an international arbitration, the award is given and the matter is settled, nothing like it. And as I said, Mr. Zaiwala is great at it. He's even written a book. If I can, I'll ask my wife to give it. In fact, I got a signed copy of that book. Um, as I said, I'm very bad with names, I forget. But in that book, he has written how to go about international arbitration, what his experience has been in international arbitration. And as this gentleman said, between two countries, one paid to be paid, one not to pay, etc. And if they can sort it out, otherwise they'll have to go to international courts. So this arbitration between countries might be the best way to sort it out. Have I answered your question, or is there still something more that you would like to know?
Mm, so I think he is not present.
Acha. Oh, he asked the question and went away for a cup of tea.
And the next question is from
Which,
Suvadi Biswas.
just hold on for a minute. If I
Yes.
can find that book, just a minute. Just hold on for a minute. Man, Zaiwala book, do we have it here? Or do we have it in Udara? Divya will try to find it. Chalo, let's continue.
So the next question is, how much arbitrators earn in his initial level?
Ah, don't ask me that question. Don't ask me that question. For a lot of people, it's a post-retirement utopia. I can tell you one thing, quite a lot. I remember once I was in the court of, I think, Justice Ganu. Yeah, here is the book. by Zaiwala. Thanks, Rita.
Okay, sir.
Honor Bound by Zaiwala. Thank you. Yeah, this is the one. It tells you a lot about international arbitration, for which he's an expert. Now, how much from zero to the moon? From zero to the moon. And anyway, I won't go further into that because I'll be stepping on a lot of toes. But it's better that if you are in arbitration, the fees are settled, maximum fees for a particular time. It doesn't mean that every time you pay 5 lakhs and 10 lakhs of rupees in the matter keeps on going on and on. I have been in arbitrations where matter has ended in 1 or 2 visits. Some of them have kept going on and on. So it's better that if you are involved in an arbitration, to set the fees, get everything done in advance so that there is no heartburn later on. See, you won't be paying, your client will be paying. And just because your client is paying and you make him pay, that's not the right attitude. Uh, Everything must be done efficiently and within means. Just because you have money doesn't mean you spend it. So all those sort of things would be much better if you settle them initially before you start the arbitration process. And I know it's an expensive proposition. It's extremely expensive. As I said, post-retirement utopia. Only what else? You want to
How?
know how much? You want to know how much I would charge?
Yeah, that question is
It's
on the.
See, if it is involving uh, contracts, substantial amounts, I would charge 1 lakh of rupees a month and six at the most. That would be my limit. It must be sorted out. If suppose it were a sports matter where an athlete is involved, and obviously every athlete is um, not an Armstrong or not a Messi or not a what is the other footballer's name? Ronaldo. Everybody doesn't have that sort of money, and a sports person could see a sports person life is for maybe top life at the top is maybe for 2 years or 5 years. Beyond that, they deteriorate. It's only in India that sports people keep on going on and on. So if you lose out on 1 or 2 years, it would be extremely difficult to make a mark in anything. Another thing is if you're out of sports, and I know, I have personal experience. If you're out of sports due to an injury or anything, to get back in is extremely difficult. It's backbreaking. So if it were a matter like that and it were brought to me, maybe I would charge 1 rupee or 101 rupees from the uh, from the athlete, because I can't expect him to pay through his nose. He doesn't have the money, or she doesn't have the money. So naturally, I would modify it. So it to me it would depend on the capacity to pay correctly, not just the capacity to pay. So this is how I work. I mean, everybody else has his own way of working. I have known arbitrators to go into a flap because the afternoon lunch did not have soup. I have known arbitrators to go to sleep at 2 o'clock in the afternoon after lunch. Now, naturally, the clients get angry, and I don't blame them. They are paying through their nose, not for these sort of things. So, if you are an advocate in an arbitration matter, it is your duty to see that all these things are looked after. Right from the beginning, please make sure that things are correct. Otherwise, don't enter into that arbitration. They have now started to put caps on fees, but to tell you the truth, anything that is enforced doesn't work. Sure, so that's for fees. What else? In international arbitration, you might get millions of pounds, huh? Because the Work involved would be worth billions of dollars or billions of pounds. So in that you would get good money. Now listen to this. This is not an arbitration; it's a case. Does anybody know about the England post office scandal? Scam by the government and the postal authorities. Hundreds of postmasters have been dismissed. Some of them have been jailed, including one of Indian origin, Seema somebody. They have been jailed. And it has been found that not only the postal authorities, but even the advocates involved were in that scam. So just like litigation, even in arbitration, it is the duty of the advocates to go and find the truth and not extend matters. In that post office scam, billions of pounds have been lost. Lawyers have made millions and millions of pounds. I think it's vulgar. Hello, next.
The next is how can we expect the arbitration award?
When can you?
The question is the how can we expect the arbitration award?
If you are in the right, then you will get an award in your favor. If you are not, it will be adverse. Simple as that. It,
The next
it's like a judgment. Somebody says somebody is right, the other person is wrong. Both cannot be right, both cannot be wrong. Except if it before arbitration you're going for mediation or conciliation and you settle somewhere in between or whatever it is, some sort of a settlement is made. Next,
the next is why do people not go for arbitration when it is time saving and lots of other benefits?
there are some cases in which you cannot go in for arbitration. The normal rule is that if the arbitration award involves only two parties and cannot be used as a precedent, then arbitration is allowed. But there are certain other laws which deny arbitration because if an arbitrator gives an award, people like to use it as a precedent, which the courts don't like. So the courts have laid down certain norms where certain things can go in for arbitration, certain things cannot go in for arbitration. I know lawyers have a uh, very nice habit of saying everything will go into arbitration. It does not work. You cannot have each and every dispute arbitrable. It's just not possible. Next,
The next question is sir after LLB earning कैसे करें as a fresher?
after LLB,
Yes sir.
what is it after LLB?
Earning कैसे करें? पैसे कैसे कमाएं?
I wish I knew about it. I would be very happy if I knew how to make a lot of money. Um, See, it's difficult to build up a good practice. Initially, you will find it difficult. There will be a lot of temptations. You have to bear with that. Take up almost any case and every case that you get, but try to avoid crime matters because the repercussions can be rather great. Study on the job. Don't take up too many matters. Take up small matters. As I said, your society matters or your wills. You start with that. Now, if you start writing wills, helping people write wills, what will happen is you know the intricacies of writing a will. What happens was, then you might come across a matter, a testamentary matter in a court of law. Take that up because you've already been writing wills for people, drafting wills for people. So you know the nuances, and that will make it very easy for you to start off the practice. Or if you've been helping your cooperative society secretary, Go to the cooperative court and take up matters there. If you are an LLB by then, you can take up your own society's matters. If you are an LLB, see if you drafted wills for some people and 2 years, 3 years later, you are a lawyer. Now you drafted that will. Suppose that will for some reason is challenged. You would be the right person to have handle that matter. Testamentary matters involve a lot of money, unfortunately, because everybody wants to look at it in a way that तुम पैसा बनाता है तो मैं क्यों नहीं तुमको इतना पैसा मिलने वाला है तो मुझे क्यों नहीं it's a it's a sad attitude. In fact, I would call it a dirty attitude. But if you charge according to what you have delivered, you can get started in testamentary man. But as I said, provided you have a 2 or 3 years experience in drafting wills. Because when you draft wills, you will know the problems. You will look up the books. You will try to solve the problem from the books. So when you enter the court in a testamentary matter, you are at least half prepared, if not fully prepared. So that's one way in which you can start earning money. Otherwise, sit in courts, ask some senior lawyers whether you can help them, whether they would pay you for their services. People pay, big lawyers pay youngsters only to carry bags, not necessarily to learn anything, but just to carry bags they pay them. So maybe you'll be lucky enough to carry bags and learn. I can't give you a straightforward formula for that. I'm sorry. What else?
So the next question is from Ayushi Agarwal. Can we add a clause that whatever the award says, it will be abided by both the parties and would be considered as a final decision, and no party can approach the court? Will it deny any right, or is there any law which prohibits this clause?
See, you can go to court for an appeal. In an appeal, you have to prefer an appeal. But there are certain restrictions on that.
Yes, the question is next. Uh, just a second. Please give some name of some institution conducting training on arbitration. Sir, you are not audible.
Yeah, Mr. Chug?
Sir, you are audible.
Yeah, I'm back. Chalo. Thanks to my wife, she did something or the other and it's working again. Where were we? We've got 10 minutes. Let's wrap it up. Where were we? What was the last question?
Sir, the question is please give name of some institution conducting training on arbitration.
Oh, yeah, there are a lot of courses. Almost every chamber in Bombay, there are three or four places where they teach you arbitration. Um, if it's possible, I'll send you the names and you can circulate them where these arbitration courses rather expensive, by the way, quite a few thousand rupees. But I'll give you the names. But to tell you the truth, nothing like practical experience. Nothing absolutely like practical experience. No matter how many books you read, as I always say, you cannot learn to ride a bicycle by reading a book. You have to sit on the saddle. Hmm. If I can, I'll send you the names. What else? Next question, sir.
Sir, how can I become an arbitrator in list of High Court?
You have to wait for 10 years. Then you have to make an application to the High Court, telling them what your expertise is, what has happened, what has not happened, etc., etc. And then they will study your application and make you empanel you as an arbitrator. In some courts it is easy, in some courts it is difficult. In the same court where it is easy today, it might be difficult tomorrow. You have to leave it to them. But you will have to wait for 10 years before you can apply. Please read the act. There's a lot of material. I know it's a very boring act to read. It's about the worst piece of legislation that I've come across. It's very boring to read it, and so many changes all the time. But it will give you some idea of what to do. Bolo, what else?
The questions for
I'm
such a
glad that
wonderful
people are.
session.
I'm glad that people are
Yes, sir.
asking questions rather than anything else. It makes my life also easier.
Yeah. As we come to the conclusion of the insightful and engaging webinar on understanding the procedure of arbitration, it is my pleasure to extend a heartfelt vote of thanks to all of you for being a part of this session today. First and foremost, I would like to express my deepest gratitude to our esteemed speaker, Dr. Bapu Malcolm, sir, for sharing her wealth of knowledge and experience with us. Your expertise and valuable insights into the field of arbitration have provided us with a clear roadmap to building a successful career in this evolving and impactful area. We are truly inspired by your words and grateful for the time you have taken to guide us today. And a special thanks to all the participants for your active engagement and thoughtful questions. We hope this session has given you the tools and inspiration to explore the exciting opportunities in arbitration and take meaningful steps
Mr.
toward a
Chu,
successful career in this. Yes, sir.
Mr. Chu,
Yes, sir.
my heartfelt thanks to all the participants. Very rarely do we get so many people so actively involved. I am also
Right.
extremely happy. I thank all of you. I wish all of you all the best in your future legal careers. And if there is anything that you need, we are always available. Mr. Chug will share our telephone numbers and our email addresses with anybody who needs to. Good luck to you, but arbitration will take a bit of time. God bless you and good night.
Have a nice, good night. Happy learning.